Morning committee. Couple of things that may not be on the agenda we'll take up in just a little bit. We have a housekeeping matter. We did pass out House substitute, Senate substitute, Senate Bill 84 last Friday. We found some problems in it. With that, I will look to Representative Epley.
Thank you, Mr. Chair. I would like to make a motion for this committee to reconsider House substitute for Senate 84.
Thank you. If you remember, committee, we've had to do this before on one other occasion, so you should have a second from Representative Highland. Oh, I need to also welcome Representative Highland back in his old slot as Vice Chair. Our present Vice Chair is in Texas. If she's on WebEx, I hope she's had a good weekend with her family in Texas. With that, I'm going to look. I'm going to touch real closely with the IT. Who's on WebEx as far as members?
Samantha Potter.
And Samantha, are you in the building? Samantha Potter, are you in the building? Apparently she's on WebEx, but must not be in the building, or at least can't hear me, okay? Just want to make sure. We have a motion to reconsider House substitute for Senate substitute 84. All in favor say aye. Those opposed, no. The ayes have it. The ayes do have it. Bill is reconsidered. Matt, you're on, correct?
I am, Mr. Chairman.
Thank you. I'll go back to Representative Epley.
Thank you, Mr. Chairman. At the end of our working of the bill Friday, I made a motion to lower the tax on the racing facilities to the same level as the casinos. I would like to withdraw that motion with all due respect, Mr. Chairman.
Thank you. The second on that, I believe, Connie, was Representative Armberger, who's not here, so I'm going to look to the replacement. Do you have any objections? Okay, there's no objections. I have a motion to withdraw the amendment that Representative Epley entered into at the very last of the committee. It probably did not get good consideration because it does not, in my opinion, has nothing to do with sportsbook. Any discussion? Yes, Representative Carpenter.
Thank you, Mr. Chairman. I just want to let the committee know that I'll be opposing this amendment. I think that it's always good whenever we can reduce taxes and allow, the private sector or whoever to benefit from that. And so I'm going to be opposing this amendment. Thank you, Mr. Chairman.
Thank you. And I would advise the committee, I oppose taxes every chance I get, but it needs to be in a separate bill. Anyone else for discussion? Yes, Representative Howe.
Thank you, Mr. Chairman. Can you withdraw an amendment, or do we need to strike the language from the bill since it was already amended into the bill?
Well, that's the reason I have Matt on the line, and I'm following his procedure here. And when we vote to allow him to withdraw the amendment, it will then be struck from the committee report. Is that helpful?
I guess from a procedural standpoint, I was just wanting to make sure that we were following parliamentary procedure, and since the amendment had passed in committee, it amended the language of the bill, so technically you can't withdraw an amendment.
Then I'm going to go to the reviser. Matt, since we're on a motion to reconsider, and then if that is granted, then we would have to pass the bill out again. Do you have some clarification or some recommendation? I think we talked about this.
Certainly. Thank you, Mr. Chairman. So the bill is back in the committee as it was amended and passed out by the committee. The way I interpret the current motion by the committee is to strike the Epley amendment from the bill. And so that's there's a motion on the table that I'd interpret as striking the Epley amendment from the bill.
That's correct. Further discussion? Oh, I'm sorry, Representative Smith.
Thank you, Mr. Chair. I just need refreshed on what exactly that amendment did, and what we're striking.
Representative Epley?
Thank you, Mr. Chair. I'll do my best to answer your question. Because this does include the race events and the Greyhound tracks, the racetracks, they are charged if they have slot machines or other machines in their possession at the racetrack, they have to charge a tax, I think is 40%, as opposed to the casinos, which have a level at 22%. I was just trying to seek tax parity in that amendment, and I'm withdrawing that amendment because there really are unforeseen circumstances that I did not understand and was educated on at some point. So.
And I would clarify that it has nothing to do with sports book. It has to do with casino. To do that, they should be bringing a separate bill. That would make that correction. Further yes, Representative Miller?
I think the representative just misstated the motion. He said he was moving to withdraw his amendment. As I understand,
Striking.
you're entertaining a motion to amend by striking the language.
That is correct.
Okay, well, let the record reflect, as it should, that I was the only member recorded as voting no on the ineptly offered Epley amendment. Thank you.
So recorded. Further discussion, seeing none. All in favor? Oh, I'm sorry. Yes, Representative Jacobs?
Thank you, Mr. Chair. Do we have a recording? If we know that there was a no, do we know how many yes there were?
I have an independent recollection. I don't know if you recorded your vote with the, or not.
Yes, I did, because it was such a horrible amendment. I wanted my vote to be recorded in perpetuity. So someday, not realizing it would come so quick, I could sit here and say, I told you so. Thank you.
Thank you. We should have heeded your guidance. Further discussion?
Excuse me, Mr. Chair. So since Vic was the only, or the representative was the only one who voted no on it, 22 other individuals voted yes on it. I guess that's what I'm asking.
It was a oral vote, so there was no recorded other than if an individual wanted it recorded.
Okay, thank you. That's what I was trying to clarify.
Thank you. Representative, you may close.
Thank you, Mr. Chair. Again, just want to state for the record that there are unforeseen consequences with this amendment, and whether we withdraw it or strike it or whatever language, it needs to be out of the bill at this time. So with that, I close.
Thank you. Chair considers this a friendly motion. All in favor, say aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. Motion is approved. Chair has a motion now. Chair makes a motion to pass out House substitute for Senate substitute, Senate Bill 84. Have a second from the Representative Highland. Further discussion? Seeing none. All in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it. Division has been called for. All in favor of passing out, which is what we did last Friday, House substitute for Senate substitute 84. Raise your right hand. Those opposed? Do it again. Take it. Raise your hand. Into 9. It does not pass out. You will see this again in the near future. The bill remains in committee. Now, let us take up House Bill 2184. Now, folks, this is the medical marijuana bill. This is going to be a slow-paced bill. There's a number of amendments. So, as to the committee, what is the pleasure of House Bill 2184? I have a motion. Epley.
Thank you, Mr. Chair. I would, for the committee's purposes, I'd like to move we pass out 2184 favorably for passage.
Thank you. Do I have a second? Representative Reese, discussion. Representative Garber.
Mr. Chairman, my secretary is still currently running off that amendment. I don't know when she'll be done, but that balloon amendment.
Right. Okay.
So
you don't have an amendment at this time.
Let me run up and see, and I can start explaining it. But she's running off the 25 copies.
Okay.
Let me go up and see quick.
Very well. Representative Howe.
Yes, Mr. Chairman. I might not have received the most updated revised agenda, but I think we had it down for Tuesday and Wednesday. Is that correct? Or did something?
I did mention on Friday when we passed out that we would take it up Monday and Tuesday. And it was on the docket. And also the statement was final action on bills previously heard, which is standard. And this is going to take 2, possibly 3 days, 3 periods. And first, while he's doing that, I'm just going to open it up for discussion from the committee on what your thoughts are. Is this something that the committee thinks that's important? But I'll just open it up to discussion. Is there any discussion? Sorry, Representative Carpenter.
Thank you, Mr. Chairman. So my office assistant is on the way with my amendments as well, but I was curious if we could get started having the reviser discuss it before the physical copies get here. Would that be permissible?
It would be.
Okay, thank you, Mr. Chairman. Reviser Sterling, if you could, with the amendment that you've sent me that has the 2 attachments, you can pull that up for folks.
Mr. Chairman, while he's doing that, I have a question. I also have some amendments, and I thought the process, they would come from the revisor's office. Do I need to go fetch those and bring those to Dave to this meeting?
Well, we're waiting for a number of amendments. Tell you what, let's just stand in recess for 15 minutes. We'll come back at 9:30. By that time, Representative Garber may have his amendments. Representative Carpenter may have his amendments.
Yeah, I just got 5 more she said that she's working on.
And
So.
Would that be agreeable to everyone? Then we stand in recess. It is 9:15 till 9:30. It's time to start. Representative Carpenter, were you able to get your amendments? Thank you. Does not look like Representative Garber is back. So, we had opened the bill, we were at discussion, we took a short recess. Representative Carpenter, are you prepared to go forward?
Yes, sir, I am.
Thank you. Call up your first.
All right, thank you, Mr. Chairman. If the amendment could be distributed to the committee at this time, and if the reviser would like to go through it, I'm more than happy to try to do cleanup, because I think I'm sure he'll do a fantastic job.
Okay, it's all one amendment, would that be correct?
At this current point in time, it is a bundled amendment with a whole bunch of changes in it.
Thank you. Matt, if you would go through the amendment that Representative Carpenter offered.
Thank you, Mr. Chairman. I'll just kind of walk through the changes as they appear in the bill. The first one is on page 3 in the definition section to the definition of veteran. It clarifies that veteran includes any member who has served, any person who has served in the Space Force or in any state, Air or Army National Guard. Just to clarify that if somebody could be in another state's Air or Army National Guard.
Thank you.
The next changes are on page 5 of the bill, requiring that if a vacancy occurs on the advisory committee, the Medical Marijuana Advisory Committee, that vacancy would have to be filled within 21 days of the vacancy, and also requiring that that committee would provide an annual report to the legislature concerning any concerns with or recommended changes to the Medical Marijuana Regulation Act. The next change would be on page 10 of the bill. It makes two changes. One, just striking some language there in paragraph 9, clarifying a conflict that existed in the bill, and also striking section 16, which dealt with the Secretary of KDHE entering into a reciprocity agreement with other states for medical marijuana ID cards. And that's striking the rest of section 16 on page 11. On page 14 of the bill, it would require that anyone requesting that the committee make a recommendation on an additional qualifying medical condition. If the committee had not made a recommendation within 6 months, the submission would automatically be denied or recommended for denial. The other change, if you see on section 20, for a cultivator, it strikes the provisions pertaining to the adoption of rules and regs to identify disqualifying criminal records or convictions. And it inserts new section 20, which is an attachment to the balloon, which I'll go to now. It's in the back, towards the back of the balloon. So I'm sorry. Let me see here. New section 21 is what I meant to refer to. And new section 21, which is attachment 2. This section, a lot of the provisions would be familiar to KSA 41.311 pertaining to the alcohol. These are a number of the licensure provisions in terms of offenses or various things that prohibit or prevent somebody from obtaining a license. So this attachment would, rather than having those disqualifying offenses be established through rules and regulations, this would put in statute a number of the same provisions that disqualify an individual for licensure under the Liquor Control Act. There's some slight tweaking with it in terms of age requirements, to be at 18 years of age instead of 21. And the primary addition to this provision is paragraph 3 on page 2 of the attachment, which has some additional requirements about transferring a license and change of ownership, and it would require certain equity requirements be for in Kansas residents. So ownership of an entity would have to have a requirement for Kansas residency of those owners. Maybe I should stop. I don't know if there's questions or the representative wants to discuss any of it.
That's probably a good,
I can go through now, Mr. Chairman, or, I mean, there's still a little bit left that the reviser could hit, and then I could just come back and get everything and the reason why I put this all in here, if you would like to do it that way. It's up to you, Mr. Chair.
thank you. I'm going to first ask if there's any questions to the reviser on this first part that he has kind of went through. Representative Highland?
Thank you, Mr. Chairman. On the first attachment, which is new section 20, is that correct?
We haven't got to that section yet.
And does that one, I've tried to read it quickly, but does it disallow all advertising? Because on the second page of the attachment, it's talking about what you have to do if you do advertise. So what does it do?
The reviser has not covered that section yet. Mr. Chair, if you'd like for me to discuss that section at this time, I can.
Let's wait till it's proper time.
Thank
Very
you.
well. Matt, go ahead and we'll cover it all and then come let the carrier of the amendment go back and explain.
Very, very good. So yes, the bill also inserts, or the amendment also inserts new section 20, which is pertains to advertising for medical marijuana. The language in this is very comparable, although changed slightly, to Connecticut's existing statutes on advertising for medical marijuana. It does a number of things in terms of prohibiting cooperative advertising between cultivators, dispensaries, and physicians. Has requirements in terms of false or misleading advertising. Would require the let's see if I can pull that up. It has a number of prohibitions on what cannot be contained in an advertisement. Would require that an advertisement for medical marijuana be submitted to the Secretary of KDHE for review. Details the requirements that were part of that submission to the Secretary. And then the Secretary could require specific disclosures to be made for the advertisement. Subsection H puts restrictions on the external signage that a dispensary may have. Subsection I, and then Representative Carpenter, I have to slightly tweak this as well still. The subsection I would prohibit the price of medical marijuana from being advertised. And then there's a prohibition on the use of billboards along state highways. So that's that new section 20. Going back to the rest of the amendment. This is another conforming amendment pertaining to that section 21 with those licensure requirements. The same on page 20 and page 21. Any person that submits a petition to the director of ABC requesting that a form or method of using medical marijuana be approved is reviewed by the director. Any petition that was rejected by the director, this would clarify that it could be resubmitted after 24 months had elapsed. On page 24, it would state that upon a finding that a dispensary licensee had knowingly disclosed patient information to any individual, the director would be authorized to impose a civil fine of $5,000 and to revoke the licensee's license. And this is a clarifying, just adding the word medical into the new section 44 before marijuana. And that's the remainder of the amendment. And I'd be happy to try to answer questions.
Thank you. Questions for the reviser? Then, Representative, would you further explain?
Yes, thank you, Mr. Chairman. So I'm just going to walk through this, if that's permissible by the committee, because this is a hefty amendment. In certain parts, it's, I would say, non-controversial in other parts. So going back to the beginning of the amendment, just adding Space Force and any Air or Army National Guard, I think that one's pretty non-controversial as far as a veteran goes. The reason why on page 5 I wanted to add a 21 days to fill such a vacancy is because there are many people who can appoint to this commission or to this advisory committee. And I don't know if someone might have, some sort of, well, I'm not going to appoint this person for a certain amount of time until a vote happens. I just want to make sure that after 21 days that position is filled by the current appointment authority, just adding a little bit of a timeline on there. The next amendment after that one is just right now we have reporting requirements inside of the bill. As you can see, they have to report to any recommendations to the Secretary of Health and Environment, currently the Secretary of Agriculture. I think there's an amendment to strike the Secretary of Agriculture, and the Director of Alcoholic Beverage Control. So I wanted to also go ahead and add that they would come and present to this committee and Health and Human Services as well, just so that we can kind of monitor what it's looking like out there as far as our medical marijuana policies if this legislation were to pass, and if there's any tweaking or anything else like that they've just saying, what you guys passed in this section just isn't working for us. Here's a recommendation on how we think it would work better. I think that we'd get some value out of that. New section 16, which is the reciprocity of licenses. Right now, it is a federally illegal substance. I think that we can discuss reciprocity at a different time once we kind of, get this law into effect and ultimately have that discussion at a later date and just see how we could marry that into our current legislation better. Because by doing it this way, there's a lot of rules and regulations in this bill, and I just wasn't comfortable with leaving that portion of it up to rules and regulations, and I would prefer if we defined it at some point in the future, more here in this committee. The next amendment is on page 14, and I added this timeline in here because I didn't want for the committee to make a recommendation they had 6 months to make such a recommendation to the Secretary of either approval or denial. The reason why is because I didn't want somebody to ask for some disease or what have you be covered and then just never get a response. And it just kind of sits out there cycling, and basically this will at least allow us to at least get a response, whether the committee would like to take that up or not. So if you all go to new attachment 1 at the back of the bill, this, as the reviser said, I wanted to make sure that we had some advertising language in here, because one of the things that, I've heard that goes on in Oklahoma is that this is a miracle pill, this will cure your cancer, this will cure XYZ, this will do so on and so forth, but yet there's no actual medical data or information to back that up. And so I felt like if people are going to provide advertising to our constituents, they have to at least be giving factual information based off of medical studies, that kind of a deal. It doesn't ban advertising, I think, like the former representative was talking about, but it does add specific requirements on what people must do in order to advertise, and the Secretary of Health and Human Services has the ability to review or deny such an advertisement if they believe it's false or misleading without adding the appropriate disclosure information. And then the dispensary information down at the bottom, as far as regulating what a dispensary has the ability to look like on the outside. And then there was a little bit of an update that hasn't occurred under subsection I that the revisor alluded to. Not just the price information, but basically any billboards along state highways would be prohibited with this amendment. And then on attachment 2, this in large part brings over what we currently use as standards for our liquor licensing. So liquor is a controlled substance. This will be a controlled substance. So I felt like, why not use the same standards that we already use for liquor? And so brought most of those over. However, what I did do is I had him leave off the 3-tier language. So the 3-tier licensing language that was in 41-311, you will not see it in here. That has been removed at this current point in time because I felt like the 3-tier argument is something that we should consider by itself if we were going to consider it. And then the new section to this is that we already have that you have to be a Kansas resident. However, what I wanted to make sure was that we had a Kansas resident who was the owner and operator, and that most of that money stayed here, and that we didn't have some outside entity that was just using somebody as a shell and basically saying, well, hey, get this license in your name, but I'm going to take most of that money from you. And so that's where that additional language comes in to that portion of it. And then if we go back up higher into the bill to pick up where we left off on page 14, basically it just removes the rules and regs like the revisor was talking about and those sections that are now crossed out and that he has flagged with a balloon. And under the current bill, the way it's written, if you were to petition the secretary, or is it the director? It's the secretary. So the secretary has the final decision to basically say we're not going to permit a new form of distribution. So like if there's a new way to oil or whatever, and somebody tries to petition for that, it says that the secretary's decision is final, but it doesn't give the opportunity for if there's other medical research done or if there's anything else that happens. So after a 24-month period, I felt like if that a 2-year period is long enough for maybe some other medical information to come out about a distribution method to potentially maybe change the secretary's decision on how this item can be consumed. And so I wanted to add that little item in there so that somebody could potentially come back if they felt like they had enough proof to resubmit their petition again. On page 24, I wanted to add this amendment that I think we need to protect patient information. And if a dispensary knowingly gives out patient information, then I think that they should potentially be punished because of it. Now, I will remind the committee that there is a difference between knowingly and other there's attorneys here on this committee that can describe this a lot better than I could, but knowingly is a standard that we hold people to where you have to go out of your way in order to facilitate it. Recklessly would not be such a high standard, so they would have to know that they are giving out this patient information. And so that will hopefully alleviate some concerns about that. And then on the final amendment, there were just 2 words in the bill that didn't have medical in front of the word marijuana, and so adding the word medical marijuana in front of those 2 words. With that, Mr. Chairman, I'll stand for questions and would appreciate anybody seconding this amendment. Thank you.
Thank you. Representative Hauser?
Yes, thank you, Mr. Chair. I got 3 questions, actually. Let's go to, you just briefed on it a while ago, page one where you had 24-month waiting period.
It's on page 23.
Right, exactly. Personally, I think that's too long of a time. I would suggest maybe 12 months.
I'm more than happy to leave that up to the will of the committee.
And then I had another question. It was about attachment 1. No, it was attachment 2, pardon me. when you go in there and you talk about the licensing restrictions, there's one in here that required a four-year residency. You know, just last month, we redid an alcohol licensing deal because the residency was cut down by Supreme Court, so I think this would probably be in the same flavor.
Thank you for the question, Representative. As of right now, there are no court opinions on residency requirements for marijuana licensing.
All right, I just wondered how you got around that. Thank you, Mr. Chair.
Thank you, Representative Heiberger.
Thank you, Mr. Chair. I've been going through this, and there's a lot of stuff in here, and I really hate to do this because I think most of it is things I can live with, but there are a few that aren't. So I would request division of the amendment.
I didn't get your question.
Well, I'll just cut to the chase. I would request division of the amendment.
He's asking that we
Division of the amendment? Yeah. Well, at the appropriate time, I will take that up. Well, this is my plan, folks. I'm going to hear each of the amendments because these are, my understanding, all these amendments are going to be vast. They're going to long. I'm going to get all the amendments offered. I'm going to, we hopefully get this before the end of committee. You take them all home with you, read over. Tomorrow you may have more questions. And then at some point in time when we've got all the, because I understand there's going to be like 20 amendments. And some amendments may remove certain language in one of the other amendments, and that's the reason I'm going to give Matt, our reviser, an opportunity to show where there is conflict in the different amendments, and then we can maybe reconcile those at some point in time. So I'm going to let the representative go through his amendment, and then I'm going to go to Representative Garber, who has a very large amendment. We have time. I think Representative Epley has an amendment, because I just don't want to do this on the fly. I want everybody to understand each of the amendments, so I would hope that you would take these back with you, spend a lot of time with them tonight. Some of these amendments I have seen, and some of these amendments I may not have seen. So, you know, this is, we're not in a hurry here. We're going to do this today. We're going to do it tomorrow, and we're probably going to do it on Thursday. Hopefully, if we get everything in today and tomorrow, Matt needs time to kind of reconcile these amendments and then come back on Thursday, and then I will ask them to present their amendments, and then we, at that time, may or may not vote on those amendments. It may be another day, but let's just go through each amendment. Then we'll take them home, we'll look at them, review them, see if there's some conflicts between the First Amendment and the Third Amendment. We don't want to pass one amendment and then strike that amendment in the Third Amendment. So that's my plan. Representative Resman, I'm sorry.
Thank you, Mr. Chairman. On attachment 1 on advertising, I wanted to make sure that they have the ability to advertise on TV and radio, or they will have the ability.
They should, is my understanding, and the reviser can correct me, or the reviser, with the permission of the chair, can weigh in on this. My understanding is as long as they meet the requirements of not false or misleading information, adding disclaimers, following the provisions laid out in this, they should still be able to advertise on television and radio. Is that correct, Mr. Reviser, if I may?
Is that helpful?
Yeah, I was just wondering, because Missouri is going to have medical marijuana, and if this passes, so will we. And in the Kansas City area, I don't know, they should identify which state they're talking about when they advertise, because there could be some confusion.
Well, that is a great question, but if they are advertising in a Kansas market, then they would have to follow the Kansas laws.
Okay, I was just wondering if they should identify the state, because most of the TV stations and radio stations are in Missouri, and they'll be broadcasting into Kansas.
I'll have to pass that one over to the reviser.
Matt, did you hear the question?
Thank you, Mr. Chairman. There's nothing in the amendment that prohibits television advertising. And I don't have an answer in terms of if there's any federal regulations by the FCC on that. So I'd have to review that to give the committee a complete answer.
I was just wondering if it should identify the state that they're advertising to. In other words, if it's Missouri Station that's there's an advertisement and they're advertising for a Kansas product, should they identify this applies to Kansas residents?
Matt, I'll leave that question to you.
If that could be a requirement if that's what the committee would like. But I'm gonna double check on the television advertising so I can give a better answer to the committee, and I don't have that information right now.
Remember when we had the lottery, it was confusing because people in Kansas thought that some of the money was going in Missouri was actually coming to Kansas.
Great question. Thank you.
Mr. Chair.
Representative Reese. He has a question, then I'll come to you.
Thank you, Mr. Chairman. And I will direct this question to Matt, and then maybe the representative who presented the amendment can answer. When medical marijuana is prescribed by a provider, does it not become regulated, the prescription, like regular other pharmaceuticals, and HIPAA guidelines would oversee the dispensing of the information of the person who is being prescribed to?
I'm sorry, I could only hear part of the question. I would note what I did hear. I would note that it's not prescribed. It's a recommendation by a physician. It's not a prescription.
So there's nothing goes through any type of record keeping or anything like that as regular pharmaceuticals?
I'm really having a hard time hearing you, Representative. I'm sorry.
I'm sorry. So you're telling me that right now, the record keeping for people who are prescribed medical marijuana, the qualifications to have a underlying factor to be prescribed it, how's that documented if not, you know, the pharmaceutical is not prescribed? This is just recommended, so you're saying that the doctor can say, hey, I suggest that you use medical marijuana? So the regulation on that, that's very lax. So my question is, there's no guidelines to save the person's identity or ailment that requires them to use medical marijuana. Can you clarify that for me, please?
So the physician, trying to remember. The physician that recommends the medical marijuana treatment submits a report to the Board of Healing Arts regarding their observations and effectiveness of medical marijuana in treating patients during the year. There's going to be a reporting requirement to K-Trax from the dispensary with when patients bring that recommendation to obtain medical marijuana. But that, you know, that could be an issue that you look at to add additional information.
Thank you, Matt.
No other questions? Oh, Representative Heiberger.
Yeah, just a quick follow-up to Representative Reese's question. It seems like one question is whether a medical marijuana dispensary would be a covered entity under HIPAA, that'd be subject to HIPAA rules. And I guess if the Board of Healing Arts is getting identifiable patient information as well, whether they would be a covered entity for that purpose. Thank you.
Thank you. Representative?
Yeah, I just wanted to provide further clarification to the representative from Johnson County. So on the advertising amendment, it does say that a cover letter has to be sent to the KDH&E secretary and have certain things listed as far as what their advertisement covers, and here's what they're going to say specifically. And in that, they have to have a brief description of the format and expected distribution of the proposed advertisement. So they have to list who their proposed audience is targeting.
Thank you. No further questions on this amendment. As I indicate, I'm sorry, Representative Hoyt.
Thank you, Mr. Chair. I was wondering if the reviser could walk us through what the penalties could be if a Kansas resident has a medical marijuana license and brings it to another state, and vice versa. If someone comes into our state with theirs and it's not recognized, I think that's a good point, that it's federally illegal. I want to make sure that we're not setting folks up for trouble.
Direct that to the reviser.
To clarify, so you're saying, what is the question, what the penalties would be for somebody who was not authorized under the Medical Marijuana Regulation Act to possess medical marijuana?
Yes, and since this amendment strikes the reciprocity, which it appears the way it's written, it's a equal to or greater than. If we strike that, what are those penalties?
Okay, thank you, Representative. So if the committee looks on page 39, it's section 56. I'm sorry, it starts on page 38. Possession of the medical marijuana would be a $400 fine if it was not more than 1.5 ounces, and the individual had a statement from their physician recommending the use of medical marijuana. So that could be an out-of-state person who had less than 1.5 ounces, and they had a recommendation from their physician for medical marijuana. If the substance involved was medical marijuana, and they were registered, it's not a penalty. So for someone who's not registered in the state, but has less than 1.5 ounces and has a statement from their physician recommending the use, it would be a non-person misdemeanor punishable by a $400 fine.
Thank you. Further, yes, Representative Carpenter.
Just one final follow-up, Mr. Chairman. I think we could tighten the language up a little bit to where if somebody is a person with a medical marijuana card from another state, then they have the ability to travel through Kansas or what have you. But with the reciprocity, that means that they'd be able to come into Kansas, buy our medical marijuana, and we could go to their state, buy their medical marijuana. And so I think that adds a whole new level or layer. So I think that we could clarify maybe that a little bit. That, if they are registered in another state and have their identification card, then we're not going to slap them with a
Right, and we had that language in another bill before, where if you're from Missouri and you're going to Colorado skiing, if you have your medical marijuana from Missouri and traveling to Colorado, that you would have an affirmative defense. If the police would stop you, they would give you a summons, and you would have to produce to the prosecutor all your documentation. And that may not be very difficult to do, and Representative, I may ask you to work on that.
Yes, sir, I can.
And I think Matt has that language.
I can ask the revisor to work on that. I just want the committee to know that this is only some of my amendments. The revisor has not completed all of my amendments, and so
thank you.
Bringing more as we
you just keep bringing good stuff to us.
All right, thank you.
I'm going to put it on hold at this time.
I understand. Thank you, Mr. Chair.
And I have other folks that have an amendments. Representative Garber, we have about 25 minutes. Can you get through your amendments?
I believe so.
Thank you. Then do we have those? Would you hand those out? Go ahead, Representative Garber.
Mr. Chairman, if I may, my amendments have an explainer with it, so I can briefly go over it, and like you said, they can look at it tonight, and if they have questions tomorrow, it'll be good. So, but I will say a few things. When we first heard this amendment, we had quite a few in a coalition that were proponents of the bill. There was like 11 in the coalition, members who have worked on the bill, members from the Nurses Society, people who have worked in the industry, and I came to them and said, asked them if there were any changes that could possibly be made to make it better. This bill was based on, I believe, the Ohio bill, and they've since made many changes in their bill. It was pretty restrictively regulated at that time when Ohio passed their bill. They've previously made some changes to loosen it up a little bit. The balloon changes are going to fall into two major categories. Those amendments directly affecting or addressing patient needs, and those to ensure the healthy, competitive medical cannabis market. If we're going to pass something, it's my hope that we pass something that will benefit those who need it the most. I understand that, I understand the law enforcement's concern, I really do. But I think we really need to put the needs of patients who seem to be responding very well in other states to the medical cannabis. The changes that directly affect patients' needs are the limit on the ban on vaporization. We have specifically identified vaporization as something where the product comes in contact with the heating source. We've said that cannot happen, and that eliminates electronic cigarettes. But there are a few vaping materials that the people take in by mouth which do not, how can I say it? The product isn't combustible, combusted. So they are getting the maximum that they can get in. And I understand the concern there also, but there are many young children who benefit from the nebulizer form of dispensing this medication, or product, I should say, not medication, but product that they can't get any other way. It's the fastest way for them to get it. Well, I shouldn't say they can't get it. They could eat it, but that takes a lot longer to take effect. So while we did limit some of the vaporization, we kind of opened that up a little, and you'll see when you look at the bill. We changed some qualifying conditions. We broadened the list of amendments that is in the statute, and we deleted some sections that I think were just kind of redundant. We set a physician relationship tenure, and this is all basically right out of my explainer, and I'm not going to elaborate too much since we're short on time, and I apologize for not having this ready. I didn't realize we were going to work it today, but that's fine. We kind of re-identified or omitted some accessories and paraphernalia language. We also deleted redundant new crime section. So that was on page 29, I believe. We also, one thing that we did that was last minute that Matt did at midnight last night, the nurses, part of the coalition that came up with these changes, not just the APRNs, but the nurses were concerned that if they were caregivers to somebody who was legally using this product, that they might have their license revoked. So we put the nurses and the LPNs, RNs and LPNs in there to protect them from losing their license. We eliminated caps on number of licenses. We changed the way we determine what to charge the person who's going to grow this. Instead of square foot per building, we did it by plant, which the coalition agreed made a lot more sense. We eliminated the Department of Agriculture, which asked and put it under the control of ABC. And we provide interstate reciprocity. So, without going into it deeply today, you have a chance to look at those amendments. You'll have a chance to read the explainer. And hopefully I'll be prepared for your questions when we finally work it. With that, I'll stand for questions now.
Thank you. I'm going to have the reviser go through your amendment, if that's agreeable.
Say again?
I'm going to have the reviser go through your amendment now.
Okay, that's fine.
Thank you. Matt, if you would go through the amendment.
Thank you, Mr. Chairman. As Representative Garber mentioned, the amendment makes several changes to a qualifying medical condition and alters the definition of vaporization. The amendment removes the Secretary of Agriculture from the bill, replaces the Secretary with the Director of ABC. On page 10, makes several changes. Representative Garber referenced the reciprocity agreement. So it's what it would do is it would allow an individual from another jurisdiction that was a non-resident to possess medical marijuana for medical purposes if they have an ID card, as long as they're not residing in Kansas for more than 180 days. It would require for a physician that's making a recommendation for medical marijuana to conduct a physical examination or a review of the medical history of the patient. It removes the petition process to the Medical Marijuana Advisory Committee requesting that a disease or condition be added as a qualified medical condition. The bill would allow a cultivator licensee to deliver or sell medical marijuana to processors, distributors, or dispensaries. It adds, the amendment would add additional requirements for the testing of medical marijuana. It would establish new fees for a cultivator license, actually new fees for all licenses. And it does have a requirement that the director, that an applicant has at least a 50% residency requirement for ownership of an LLC or corporation. Clarifies some packing requirements for licensed processors. Removes the 15% set aside of licenses for minority groups. Also, here's the additional fees established for processor licenses and distributor licenses and retail licenses. Would require the Secretary of Revenue on behalf of Director of ABC to establish standards and procedures for the testing of medical marijuana by a laboratory. strikes the new section 47, which made it a new crime, made it unlawful to store medical marijuana where it was accessible to a child under the age of 18. And then the last major change that Representative Garber mentioned was on page 70, dealing with the Board of Nursing, prohibiting the board from taking adverse actions against any licensee for their use or pursuant to the Medical Marijuana Regulation Act. And I'd be happy to answer any questions if there are any.
Thank you. Redirect me to the section where you're striking, where if you fail to secure your medical marijuana, that I think it was in there in the original bill that it would be a Class A misdemeanor. And you say that's been struck?
Thank you, Mr. Chairman. Starts on page 29. It's new section 47. Yes, violation of it's a Class A person misdemeanor.
All right. Let's see if they struck the whole section in section 47.
Yeah, so that was a new section creating that new crime, and the amendment would strike that.
Okay, thank you. Questions of the reviser? Representative Carpenter.
Thank you, Mr. Chairman. Reviser, sorry, I was looking at some stuff on my amendment. In this amendment, does it strike the relationship that you have to have with your physician?
Thank you, Representative. So the requirement that you have a minimum 12-month existing physician-patient relationship is removed. It would replaced with the requirement that the physician conduct a physical examination or review of the medical history of the patient.
Thank you.
Thank you. Further questions of the reviser? Seeing none, Representative Garber, do you have any? I just have one question. Why did you strike section 47? And that has to do with how it did read, and I thought it was important. It shall be unlawful to store or otherwise leave medical marijuana where it is readily available to a child under the age of 18.
Yeah, because we have existing legal recourses for children under 18 already. Law, negligence laws, and things like that.
Okay.
Do we have prescription medicines? We have it with prescriptions medicines. We have laws.
Right.
And why should we treat this any different? Was my thought.
It's just one of those things that I put in the original bill because I had attended a judge's training out in Denver, Colorado, right after they passed medical marijuana, and we had an ER doctor come in, and he testified the first time they brought a 4-year-old boy in, it took him 4 or 5 hours to diagnose what was wrong with him, and now he can do it within 20 minutes because someone that had medical marijuana did not secure it. It was in a chocolate bar, and of course a 4-year-old finds a chocolate bar. What's he going to do? He's going to eat all of it. And so they saw an uptick in their emergency room for children because folks just didn't secure it. And I wanted a strict liability on them. If they had it, then they had the obligation to secure it, and if their failure to secure it, then the parents or the person with the medical marijuana card could actually be charged. I guess I brought up some question. Representative Clayton?
did, Mr. Chair. I just went down memory lane. Remember when we voted on chocolate with alcoholic liquor in it? Did that have a penalty? I can't remember. I can't remember the bill number, but I do know. So was that similar?
It was initially, yes, yes. Other questions of the bringer of the amendment? I've got about 10 minutes left. I know we have other amendments. Representative Howell, do you have a question?
Thank you, Mr. Chairman. Representative, you had mentioned there was something in this legislation that would treat it by plant and not per square foot. Could you go into that a little bit more? I don't have it. I just heard you mention it, and I was trying to find it, but couldn't find what section it was in.
It's on page 16, section 23.
Thank you, Matt.
Okay, originally we had, let me look, like $4 a square foot. See the reference. Matt, can you help me? I don't see the reference for $4 a square foot in the original bill.
It sounds like, Representative, that I think you made copies of an old version of your amendment.
Okay. Matt, in the original bill, it did tax based upon square footage, did it not?
So,
if you recall.
So in the original bill, there wasn't a fee on square footage. What there was a cap on page 15 on the amount of square feet that a cultivator could use. So right now, if you look on page 15, section 21, we have level 1 and level 2 cultivator licensees, and they have square footage requirement or ceilings basically for how much square footage of land they can or area they can use to develop medical marijuana, to grow medical marijuana. So the proposed amendment would strike that reference to the square footage cap, and then separately the fees for cultivator licenses, the updated that I think that Representative Garber intended to provide copies to the committee of would have an annual fee of $5,000 for the license application, and then a $20 fee per plant that was paid at the time of licensing and each annual subsequent renewal for the maximum number of the flowering medical marijuana plants that would be declared by the applicant, and basically the max that they could cultivate at any one time in the facility.
I remember now, Representative, we had talked about $4 per square foot, but with this method here, it would be by the plant. Plant can take anywhere from 4 to 8 square foot is what I understand. But the thing of it is, many people have one plant on top of another. They layer the plants. So the coalition really thought that this would be a better way to do it, and I took their word for it.
Thank you for that. I was just kind of curious. I wasn't sure how many growing seasons you could have in a greenhouse, and how there could be potential to get around maybe paying less taxes depending on the harvest time and things like that. So I know a square footage is a set amount, and that's usually not going to change unless you're adding on or things like that. So I was just kind of curious. Thank you.
I understand it, but if you have a greenhouse, as you explained, previously stated, it may be a big greenhouse, and you may want to just be starting a business, and you may not want to fill it up. You may want to start with, and I don't know this, maybe say 250, 500 plants. You had more square footage than that. If you had to pay just on the square footage, of the building, then that would be one amount, but it would give you, if you started out with 500 and said, well, this is starting to be profitable, I could go to 1,000, and it would be an easier count to say, okay, I'll just, or whatever my facility would hold. Folks, we got 5 minutes here. What I'm going to ask, I believe Representative Epley, Representative, would you mind handing out your amendment, handing out the amendment so folks can go through it tonight and then discuss it tomorrow? And you have how many amendments? 2? I just don't have the time. Go ahead. You got a minute.
I'll be really quick, Mr. Chair. There's basically 3 amendments. One is the Board of Healing Arts amendment about how people are regulated. Second amendment comes from the State Chamber, and it's about allowing businesses to continue to have their own drug policies going forward as it relates to THC. And the third one, which is the big one, has 2 big attachments, and it discusses the physician relationship, which I changed in amendment. It discusses pharmacy involvement, and finally laboratory engagement for quality assurance purposes. And that's what these 3 things that are coming to you. The first one is 1 page, the second one is 4 pages, and the third one is more pages. And I think these items are all important to the bill, as we have discussed, Mr. Chairman. Thank you.
Thank you. We'll start back up at 9 o'clock in the morning and go through. We'll start with Representative Epley's amendments, and then we'll take other amendments as we go through. I'll hold on for a minute while the amendments, make sure everybody has those amendments. Thank you. Representative Hauser.
Thank you, Mr. Chair. When we go to work in these amendments, what if we like parts of one and parts of another, but we don't like the whole thing? How are we going to be able to work these amendments into this in such a short time?
I don't know. We're going to work it, and if we don't get it where we're comfortable, then there's always next year. So that's speaking from the chairman, who is a big believer in a limited government, and whether we pass bills or not. But we will use due diligence. We'll try to get, I anticipate maybe trying to work this on Thursday, but I want the committee to go through all the amendments, understand the amendments, and then we will decide how we want to proceed. If there's nothing else for the good of committee, I have 1 minute. We are adjourned.